I'm Richard Knott, and with me is Rachel Dimmery. So we're both independent hearing commissioners and have been appointed by Whangarei City Council to hear submissions on private plan change Run 50 for Marsden City. So after the hearing, we will prepare a report making our recommendations to the council, who of course will make the final decision on the plan change. Obviously, being remote and online is not usual, or becoming more usual, I guess, but not usual for these things. But I think one of the things I normally try and do with a hearing is to try and keep it as flexible as possible, which often I think perhaps allows questions across the room. Perhaps if we think there's someone else in the room who can help with the question we're asking a witness and someone who's giving evidence to us. And clearly that's going to be a bit more difficult online than usual, but we'll see how we go, because I think there's still benefit in doing that if we can. We've obviously read through the council's section 42A report, the application plan change documents and the evidence on behalf of the applicant and submitters and council. We feel that we're reasonably up to speed with things. I don't think either of us have any paper copies of that information, so you'll probably catch us turning away from the camera, looking at other screens and things to try and read along as we're going through this. But please, we are listening. It's just quite hard, I think, when you're on camera to always do the right thing. So we did visit the site on the 17th of August, the day before the hearing was due to kick off originally, on our way up to Whangarei, and before we heard that there was a COVID-19 case in the country. And so we did that, and we also obviously looked, both being involved and being commissioners for the urban and services plan changes. We also looked at the site back then in 2019. I've previously stopped and looked at the site in the past too, just to on I think my first trip up north, to see what the site was and have a bit of a look around. So I've got a more of a historic view of the site as well, and can see what development's taken place since then. We also, when we carried out our site visit, looked at the immediate local area to reacquaint ourselves with it. So we understand the relationship of the site to Rural Carcathon Centre, and the residential areas at One Tree Point and Marsden Cove, for instance. We previously visited the refinery and understand the relationship of that to the plan change area too. So that's sort of the background, I think, really. But just thinking about some protocols for the day, and I think you're all doing it. If you could please keep your camera off and the microphone off unless it's your turn to present your evidence, and because I think otherwise our screens are just going to get too cluttered, and it'll be even harder to follow along. But Mr. Allen, I think whilst you're going through your witnesses, it'd probably be good if you keep your camera on. And Ms. Ryan, as I said, if you want to keep yours on, if you feel that means you're sort of part of the proceedings a bit more, by all means do so. But and that also comes down to that thing where I said I'd like to be able to, or we would like to be able to ask questions across the room if need be. If people could have their mobile phones to silent, and in saying that, I will apologise because somehow my phone connects to my PC, and despite the fact that I've turned my phone to silent, it does seem to ring on my PC for some reason. So I'm not quite sure how to tackle that if that happens. So apologies. I'd usually ask who's in the room and you're interested in the application, but I think I can see a list of names which says +10 on my screen. So I can't see entirely who's here, but I think if we try and do that, it might get a bit complex. But what I might do is, Mr. Allen, if you could just say who you've got from your team, and I'll ask Ms. Ryan to say who's there for council in a moment. And the one point I forgot to say before that was, if anyone's having any technical issues or whatever, clearly the point of contact is going to be Tyler, I think, who sent the appointments out to us. So if anyone could first try and raise anything with her, because I have to admit on Teams, I'm absolutely useless at noticing when people put their hand up and things against their name, and I'm meant to notice that someone wants to ask a question, and I don't tend to see that when I'm focusing on the people in front of me. So perhaps either probably go through the council first, and then I'll there's somehow let me know that you want me. Yeah, so Mr. Allen, who do you have?
Thank you, sir, and good morning. I'll run through the names of the witnesses who hopefully are part of the list of, I've got a series of names and plus 15. So David Badham, Glenn Bellingham, who's a civil engineer. David Adam is the planner. Matt Riley, urban design. Tim Heath, retail planning. Harry Ormiston, traffic. Peter Ibbotson, noise, and then we'd come back again to Mr. Badham. We've also got Mr. Sachs, who was fleetingly on your screen, who's the principal of the applicant, one of the applicants, and is not here to present evidence. But if you had any questions that particularly he was able to answer and others couldn't, we could certainly ask him to do that. The other thing I would say, sir, is with reference to the question of going to other people in the room, in terms of the person with the best understanding of the provisions on our side of the equation, that would be Mr. Badham, who's been involved in writing them and amending them, and that's one of the reasons why I'm going to ask him to present a presentation on the screen immediately after my legal submissions, so that he is then able to take you through where things have got to, and he is probably the most likely person to be coming in during our presentation if you have questions that, if you like, cross over between disciplines.
Good, excellent, thank you. The other thing I should have apologised for is there may be some background noise with me, and there's not a lot I can do, in that my neighbours have built a house on what should be their back garden, and now their kids play a lot closer to my office than they used to. So you may hear some squealing later on. Don't be alarmed. Ms. Ryan, for the council, could you just sort of confirm who's there?
Certainly, we've got Derek Ford for economics.
Oh, we've got some big feedback.
John Stiles for noise, and myself as reporting planner. Yeah. I'm going to let Robert Burgoyne introduce himself in the council team.
Okay, thank you.
Yep, so Robert Burgoyne, manager of the district plan team at Whangarei District Council. And just to note that we are the district council team, and Kelly, we are still in the Flames venue today. So we do have the doors open to the public if the public wants to come in. We have some giant heads on a projector screen here that the public can see. And we're also recording this meeting, which we'll post online after the hearing. But so within the room on the council team, we have Tyler Clark and Ashley Middleton, support assistants who are helping out with the team side of things and the running of the hearing. And you might get a few emails from them throughout the day. You hopefully have had a few this morning with some supplementary evidence and legal submissions. So you might get a few more from them as information comes in. And we also have Eden Edwardson, Natalie Day, and Stacey Sharp here observing from the council side of things. Yeah, so if there are any other technical questions or anything else that pops up, please feel free to get in touch with either myself, Tyler, or Ashley.
Great, okay, thank you. And I don't know which submitters we have online. It might be if there are submitters online, if perhaps you could just dive in and say you're here and you're interested in it, if that's okay. This may get a bit messy trying to do this, so let's see how we go.
Morning, sir.
Hi.
Ebony Alice for Refining NZ. It's just me this morning, but tomorrow we will also have Brianne Elliott, who is the client witness, and Blair Macefield planning, and also Richard Chilton on ODA.
Great, thank you. Any other submitters here this morning? No, okay, that's fine. No. Oh, we do. We have Mr. Hartley.
Yes, good morning, Yes, I'm watching brief, obviously, during the first day of the hearing, and Mr. Paul Gray is also coming in from time to time. He is the director of Bream Bay Village and GNLC, two of the submitters. Thank you.
Great, thank you. Any more? Yes, here we go.
Hi there, I'm Taylor Mitchell. I'm here for Kiwi Rail, and we've also got Pam Butler, who's the planner for Kiwi Rail, on the call, and she'll be on and off throughout the day.
Good, thank you. Anyone else? Yep.
Good morning, I'm Sarah Brownie. I'm here with the WC Parks and Recreation team. We have an interest from a Parks and Recreation and also infrastructure point of view. We'll be presenting tomorrow. Just to let you know, we're here and we're listening.
Great, thank you.
Yeah, I'm here, by the way, with Simon Charles, Graham Mathias and Heather Osborne. So.
Oh, okay. Yeah, all there. Good, thank you.
Cool, thank you.
Any more? No? Are we through? Okay, good. So moving forward, we'll obviously follow the standard format of hearing from the applicant, the council and submitters. I think we have some council legal representation on this afternoon from memory. And obviously we'll go through those in order, and we'll then return to Mr. Allen for the applicant's right of reply. Obviously after that we have to decide, Ms. Dimmy and myself, whether we have any other information we think we need to make our recommendations before we close the hearing and preparing our recommendation report. As for breaks, there was a schedule, I think, sent around some while ago about when we'd be taking breaks, but I think as we're now online, my preference, and it would be good to hear what you think, Mr. Allen, and clearly it has to, I think, we see how we mould it to fit with how your timing's going. But I think breaks every sort of hour and a half are quite good, because I actually find it harder to concentrate online than I think I do in person. So if it's okay with you, if we sort of think about breaking about sort of 10:30, but see how we go and how that fits. But if we look at our first break at 10:30, and then we'll decide when the next one is, when we come back after that, just as I said, to see how we go. But if we aim for about an hour and a half, otherwise it does tend to get a bit hard to concentrate, I think. Is that okay with you, Mr. Allen?
I think that's sensible, sir. Yes.
Yeah. Okay, and then final thing from me before we pass to you, Mr. Allen, unless Ms. Dimmery's remembered something that I've forgotten. Is there any limitations on any timing and availability for anyone who's here at the moment that means we need to sort of have that in the back of our mind? So if people could just come on if you've got any limitations on timing. No, sounds like there isn't. So I shall turn towards Miss Dimmery for her to remind me whether there's anything I've forgotten before we move on, if that's okay.
No, I can't think of anything. Thank you, Mr. Chair.
Great, thank you. Over to you, Mr. Allen.
Thank you, sir. You will have in front of you some legal submissions that came in last week. Now, I presume you've had a chance to read it, and that leaves us in a slightly unusual position where whether I just go through them reasonably efficiently, but sort of presenting it in full, because I'm not sure whether everybody has seen that. I know we submitted them to the council, or whether there are specific points that we should get into and discuss in particular. What you will notice is that they're slightly longer than usual, and I've tried to address some of the submitters' issues that you might normally come to in reply at this stage, because just of the nature of the hearing, trying to get the issues out and on the table as soon as we can, and our responses to them. Do you have a preference as to how I take you through this?
I think it would be useful for you to I mean, I'm sure we've both read them. I've read them. I think from my perspective, it would be good to have you take us through them, and I do have some questions. So if that's okay, given I'm scrolling as I'll be scrolling as you're talking. I'm sure we'll be both scrolling as you're talking. Whether you don't mind us interrupting with our questions at that moment. But
I think interrupting as we go along is the most efficient way of.
Yeah, that's what I hope, particularly when I've got to scroll and try and find the page afterwards. So yeah, that would be good. But I mean, we have read it, so if you sort of take account of the fact that we've read it and through reasonably rapidly rather than word for word.
I will do my best. So as I've noted on page 1, this is in relation, these submissions in relation to Plan Change 150. The applicant's constituent partners are major landholders in what has been called to date Marsden Primary Centre. It's 127 hectares of land generally bounded by Port Marsden Highway, One Tree Point Road, and the railway designation. It's that triangular shape. And the applicant is seeking to establish a viable and sustainable town centre for the Ruakaka Marsden Point area, and to that end, PC 150, as notified, proposed to rezone the PC 150 land from Marsden Primary Centre environment, which was the zone applying across the land, to a mix of zones that are specified there. The relief sought by the applicant now differs in some matters of relative detail, really, from that notified. The changes will be addressed to you by Mr. Badham, but the key amendments are the following. The first is some amendments that are made in response to the 42A report. So that came through in the evidence in chief from Mr. Badham, and again, he can take you through them. Secondly, when the matter was set down for hearing in August, there was some consent documentation, I think, that was being worked through by council and Kāinga Ora on the urban services land plan changes. That consent documentation has since been the subject of a consent order. And what Mr. Badham has done in consultation with Mr. Burgoyne and Ryan is to try and strip out from the plan change the elements that would otherwise just be repetition of or duplication of in a slightly different form, the material that's now in the district plan as a consequence of the consent order. So having done that, he's found that the length of the plan change happily has reduced quite significantly. I think it's something close to half the length of once it was. Of course, all the stuff that really matters is still there. The third issue relates to the low density residential zone. And I have on page 2 of the submissions a figure that shows on the left-hand side the notified zoning, and on the right-hand side the revised zoning, and you will see that down the eastern side of the PC 150 site, there was originally some relatively low-density residential land adjacent to State Highway 15, and that had alongside it a crosshatch, which is the bunding that was proposed through the evidence in the 42A process. Having got all the evidence from other parties in, the applicant thought, well, look, we're going to quite a lot of effort to try and deal with this issue. People still aren't satisfied. Maybe the simplest thing is simply to replace the zoning closest to the highway with the commercial zoning that's around the balance, or much of the balance of the rest of the exterior of the site. So that's what's proposed to be done. Now that involves a change from, let's call it medium or low density residential to that commercial zone. It then would have left a pocket, if I can put it on the screen, the pocket here within that block of that still relatively low density residential. And the thought then was, well, the rationale for that's gone. There's no reason why not to have the standard residential, default residential that applies on the balance of the land to the west and in fact the north of that little pocket. And that is what is now proposed in the plan to the right. In 1.4, I just set out the approximate areas of the zonings. I'm sure when the plan goes formally into the district plan, there'll be whatever numbers there are, they'll be slightly different from that, slightly refined from that, but that's the measurement is best approximated. And a note in 1.5 that the 42A report addressed the relevant statutory framework in detail. I'm not going to repeat all that, but I will make some comments as I have on the matters that we think are germane to your decision. I've then listed the witnesses, and in part 2, I come to the background, and in 2.1 refer to what the applicant perceived as being problems with the current zoning. Now, the first thing I think the point to make here is we're not trying to zone greenfields land and make it urban. This is already urban zoned land. It's, I would say, quite complex zoning, quite challenging for both the applicant or a landowner and the council to administer. And the view formed over time was actually it's not quite the zoning that you'd want on this land now, given what's happened elsewhere, given a bit more thought on what this land should be providing for the broader Ruakaka Marsden area. And I've repeated there some points that are found in Mr. Badham's evidence. I won't go through those in detail. And I just note in 2.2 that PC 150 is endeavouring to enable a compact, viable, sustainable town centre supported by sufficient land for housing and commercial use and associated infrastructure, so that these activities support each other and complement each other. That includes the deletion of the Marsden Primary Centre chapter from the district plan, the replacement of the Marsden Primary Centre environment with a mix of zones listed above, combined with a precinct that sits over the top that applies bespoke provisions to the land. And the replacement zones that are used are those that are found and really worked on through the urban services plan changes. Secondly, involves a shift away from the current provision of industry and its replacement with commercial and residential activities that are more compatible with the town centre. So I guess an observation regarding the Ruakaka Marsden area is there's quite a lot of industrial land. And if we're going to create a township settlement here that is self-contained in the sense that it minimises the extent to which people need to drive from Whangarei, particularly for employment, or drive to Whangarei for housing, then it makes sense to have a mix of activities in this area, and the zoning that's proposed is endeavouring to do that by introducing residential adjacent to a centre. There's commercial around the edge. The rationale for that is that minimisation of adverse effects and conflicts between the transport network on the two sides, the northern and the eastern sides. And of course, the land is sufficiently large to accommodate that. If you look at the zoning pattern on that previous page and imagine it on 10 hectares, it would be inordinately complex. But on the 127 hectares or so that we have here, it's there is space for interfaces between zones to be managed appropriately. And that is certainly something that Mr. Badham and the other consultants put a lot of effort into. The part C in 2.2 is the reference to consequential changes to other chapters within the district plan. Now, in one of your minutes or directions, you asked the council lawyer to advise on the relationship between some of the relief here and relief in the urban services plan changes. My expectation is that Ms. Shaw has done that. I see I've just received her legal submissions. I've not read them, but I have had some discussions with her, and I have left that issue primarily to her, and I've touched upon it very briefly, but it's council's plan, and we're comfortable for it to explain to you how it sees these provisions integrating with that plan in the most efficient way. I think in simple terms, what is sought could be managed by putting it all into the precinct, but that's a clumsy way of doing things if in fact the district plan provisions deal with it efficiently. And my preference with a district plan is to have fewer words if possible, and not to just duplicate, or worse, have similar wording but not quite the same wording in other places in the plan, because that invites people people like me to find reasons for the differences in the wording, and we can go down all sorts of legal rabbit holes where council didn't intend much change, but others are arguing that in fact there is a distinction. So we think the most appropriate way is to use the general rules in the plan as much as possible and identify where you need a specific resolution here. Part 3.
Alan,
yes.
Mr. Allen, can I just interject there? In terms of that minute, I haven't had a chance to read Ms. Shaw's submissions yet either. And the question really was that some of the submitters and the plan changes were originally notified. Due to it being a private plan change, we were seeking confirmation that it is not open to us in our decision to vary parts of council's plan which are not yet operative. So a private plan change may not vary a proposed plan change. Only a variation promoted by council may do that. And so we were seeking clarity on that point.
Right. Well, look, I'll leave that to Ms. Shaw because she has a familiarity with what aspects of the plan are operative.
Sure.
Now, and we're dealing here essentially with consequential changes, and it could be that you can say this is where we want to get to. Change it when you're able to, council, and in the meantime, there are a range of mechanisms you could use. It's really it's a question in some ways of the timing as to when sequences as to when things happen, because clearly you can vary a plan consequentially, where you've got, for example, a change to a piece of land or a change to a zone name or the like. There's some logical things you just have to go through to make your plan work. Most of the changes that are sought in terms of things that we understood were going to be dealt with through the urban and services lands plan changes are things that aren't necessarily, they aren't specific in most cases, specific to this land. They are much more generic, and the plan, once the urban and services plan changes are resolved, will have the answer to that problem, unless there's a site-specific solution. But I think I'm better to leave it to her because she does have a familiarity with the urban and services plan changes and where things are up to that's significantly beyond mine, because she's involved on every one of those appeals, and I'm involved on a very small selection of them.
Thank you.
Yeah. And if there's any more, I think, coming arising from that, I presume you'll cover that in your reply anyway.
That's my expectation, sir. Yes, and of course it has been a movable feast. Things have changed throughout the process, so hence Mr. Badham's suggestion that we are now in a position where we will be able to have a significantly shorter precinct because the plan will have resolved those issues.
Good.
Turning to legal framework, RMA provisions, I've just referred in 3.1 to part 2, and I've explained why we think this enables a more efficient urban development of a site that's already subject to an urban zoning and is strategically located in the centre of the Marsden Ruakaka area, a centre that, well, an area at the moment that is really made up of disparate parts, but I think in the long term logically will become a coherent whole, and having the intention of the plan change is to provide something that can be the core of that whole in terms of its centre function, and can be integrated because of its central location with the other areas. But as I say later, the way in which it's integrated is going to be a function primarily of how the council, the roading authorities allow things to occur and encourage things to integrate with it. We can't provide cycleways off-site. We can only provide for it within this area of land. As I say in C, it takes advantage of its strategic location on the transport network. It will contribute over time to the creation of a coherent urban form in Marsden Ruakaka. It will facilitate and encourage the co-location of retail, commercial and residential activities, which promotes transport efficiency, and it will provide high quality amenity as a consequence of the proposed provisions. And in my submission, it doesn't raise any concerns in terms of sections 6, 7 or 8. Referred to section 32 of Mr. Badham's additional work. I've referred then to section 74 and 75. The requirement in 75.3 that the district plan give effect to any national policy statement, coastal policy statement, regional policy statement. And I've referred in 3.5 to the NPS urban development, which contains objectives and policies regarding the manner in which urban development should be developed, along with obligations on councils regarding the provision of sufficient residential and commercial capacity to accommodate future growth based on an appropriate evidence base. Now, the next section deals with the National Policy Statement, urban development. I don't think I need to take you through this in a lot of detail. This is really, firstly, a comment on the Eden Epsom decision and what it may or may not mean, because I think it was a decision from Judge Newhook in the context of a private plan change on a particular site in Epsom. he was looking at whether he needed to look at the NPS for that particular purpose and decided he didn't need to, wasn't required to, and wasn't going to. There's been...
I was going to say, I would actually like you to run through that, because I'm not saying I didn't understand it, but I think it would be good to, if you could take me through it, because I think it is important just to cover that off, really.
Okay. So
I was interested, before you start, has it been appealed, or is it?
I don't think it's been appealed, but I wonder if the latest round of excitement from Wellington might have some, you know, that might have had something to do with what's triggered all the sudden burst of excitement as to what we'll be doing with development in Auckland.
Having not read this decision, it's the Brightside Hospital site, I guess.
Yes, it is.
Yeah, because I was commissioner on the resource consent, but not on the plan change.
Right.
The resource consent came while this had been appealed. Yeah. Well,
obviously, I haven't given you a copy of the Eden Epsom decision with my subs. It's the reference is there. Yeah. I've quoted a bit from it. One of the difficulties I've got with it is I think it's written in a way that has quite broad application potentially, but it's written in the context of a very specific circumstance. And I wonder if the language in the decision leads to potentially more dramatic conclusions than the judge necessarily anticipated. What the court concluded was it's not required to, and it will not be giving effect in this case to objectives and policies in the MPSUD that are not requiring planning decisions at this time. So you recall that some of the provisions of the NPSUD talk about planning decisions, and that was defined. It sort of comes back to not private plans, but the court, having considered that definition, then said, well, actually, I think they did mean to apply it to private plan changes in some cases at least. So it's a little unclear. There's a paragraph which does have a triple negative in it, and that's a bit of a challenge, I found. It then goes on to say, we acknowledge the promulgation operative status of the MPS overall, but cannot prejudge, let alone preempt Schedule 1 processes yet to be undertaken by the Council on implementation of it. Now, as I say in B, in reaching those findings, the decision noted that the definition of planning decision means a decision on a district plan or proposed district plan. Ultimately concluded that some provisions of the national instrument may be considered in a planning decision on the merits of a requested plan change, including on appeal to the Environment Court. So that discussion about the definition didn't actually inform or determine where the court got to. It said on a private plan change, some of these things are still there, still relevant. It identified the MPSUD provisions that explicitly refer to planning decisions and appeared to proceed on the basis that provisions which do not use that term need not be given effect on private plan changes. Now, I'm not sure, I do struggle to completely grasp what the court was saying, but my submission is that it is the plan, the district plan, that needs to give effect to the NPS, the higher order instrument. And that doesn't matter. That's not affected by whether it's a private plan change or a public plan change. You're still changing the plan. So paragraph 4.3 is where I make that submission. I say that if the Eden Epsom decision might be read as suggesting that provisions of the NPSUD are subject to different tests when considering private as opposed to public plan change. But it's submitted that the NPSUD is a document to which a district plan must give effect. Thus, the WDP provisions, as amended by PC 150, must give effect to the NPSUD if they are to comply with the RMA. Now, we don't need to do the things that the council has got a separate obligation to do. It's going to be introducing its new plan changes to give effect to the NPSUD. Helpfully, the bill that was put out last week says that if you're halfway through that process, but you haven't given effect to this new rule requiring 3-story buildings 6 meters and 60 degrees off the boundary of every residential site in your zone, you need to withdraw that plan change and start again. The concept of a variation seems to have escaped the thought pattern of people in Wellington, but that's a separate complicating factor. I think the point is this is a plan change that's primarily about what you can do on the Marsden land, the Marsden City Centre land. It's not primarily about the NPSUD, But when you're making a decision about it, the things that are said in the MPSUD in my submission are relevant, and we should be trying to give effect to the extent. So in B, I just say that the RMA requires the MPSUD 2020 to be given effect in district plans, regardless of the procedural route through which this provision is introduced. To do otherwise would lead to inconsistent planning approaches depending on the identity of the component of the plan change. If it's the council, it's one thing. If it's me, it's another thing. It's not helping us get consistency of plan provisions. Marsden Ruakaka area is a urban environment in terms of the MPSUD. Introducing provisions for Marsden City through PC 150 that are consistent with the MPSUD would neither prejudge nor preempt any separate Schedule 1 RMA process that Council chooses to undertake in the future. Obviously, if it does that, when it does that, it might impact what can happen on the site, but that's a separate planning exercise. Accordingly, if the Eden Epsom decision is interpreted to mean that WDP provisions regarding the PC 150 land introduced by private plan changes do not need to give effect to provisions of NPSUD 2020, then in my submission that would be contrary to the scheme of the RMA and in particular section 75.3a. I think that's what the Act is telling us we do need to give effect to. In any event, importantly, if we go back to the quote from paragraph 29, which is in paragraph 4.2 of my submissions, the court said, the court holds that it is not required to and will not be giving effect in this case to certain objectives and policies. And my reading of not required to, it doesn't say we're prohibited from or precluded from, it says we're just not required to. So that implies that you have at least a discretion to give effect to objectives and policies that do not refer to planning decisions. In that context, in my submission, it's appropriate that you do exercise any such discretion to give effect to the NPS. Now, so does that clarify what I was getting at in that part of the submissions?
Yes, it does. I think I don't know if Ms. Dimmery has any questions, but I think it was 29 and the not that was confusing me, and I think now you've run through it, it's sort of falling into place more than it had before. Thank you.
Thank you.
Do you have any questions, Ms. Dimmery?
No, nothing from me. Thank you.
Thank you. The next part of it, then I go through objectives and policies and look. So I don't think I need to run you through that in this forum. I think you've got it to read. You will have read it. If there's anything you want to go back to, you can find it. But that's a reasonably good way of saving time.
Thank you.
So if I take you through to page 10, where we turn to the urban and services plan changes. Part 5 of the submissions. Marsden Primary Centre was excluded from the rezoning elements of the urban and services plan changes initiated by Council in May 2019, and the provisions sought in PC 150 therefore could not be included within that plan change package. So the applicant would have liked to have been part of that, because then these issues could have been wrapped up in the urban services plan changes. And you might recall we came and made some submissions to the urban services plan changes, on which you were both part of the commissioning panel, and made that statement then. The fact is we've now got a private plan change to deal with the matters, for better or for worse, and hence here we are today. Accordingly, I say in 5.2, PC 150 was drafted to incorporate provisions relating to the matters covered in the urban and services plan changes, but in the knowledge that resolution of those plan changes might render the site-specific provisions unnecessary. That was a belt and braces approach adopted by the applicants and by Barkers. The intention is to ensure that if there is something specific about this site or about this proposal that warrants some specific provision, we've got the framework in place to do that. But as I've noted in 5.2, Mr. Badham's evidence records that as relevant appeals on the urban and services plan changes are resolved, provisions can be deleted from the Marsden City precinct to avoid unnecessary duplication and overlap. That's what's now occurred in terms of the now settled Kainga Ora appeal on the urban and services plan changes. Ms. Shaw will tell you how and to what extent those provisions, that settlement enables you to simply rely upon the the now operative and effect provisions of the plan changes and the plan. The Commissioners have requested an update from Council regarding the resolution of Environment Court appeals relating to the urban services plan changes, and advice as to the extent to which those plan changes are now formally operative or operative in effect. The applicant makes the following brief observations regarding the relationship between PC 150 and those plan changes, but as I say, I've left it to Ms. Shaw as the Council representative to deal with the substance of your request. PC 150 has notified, incorporated a number of site-specific provisions addressing matters that are now being resolved on a district-wide basis through the urban and services plan changes. The intention of those site-specific provisions was to ensure that appropriate provisions could be put in place for the PC 150 land, regardless of when or whether the urban and services plan changes were ultimately resolved. It is preferable in my submission to apply consistent provisions across a district, unless there is a sound basis for adopting different provisions for specific sites. Thus, if the characteristics of the PC 150 land do not differ from those of urban areas generally, the most efficient and effective method to adopt would be to rely upon the district-wide provisions for the PC 150 land that are formally operative or operative in effect. If the characteristics of the PC 150 land are such that a stricter or indeed more lenient approach is appropriate on that land in comparison with the balance of the district, then such provisions can be introduced through the precinct. So it's only if you want something unusual for this land that you would logically put it into the precinct. Otherwise, you're just doubling up on the balance of the plan. So in circumstances where issues remain outstanding under the urban and services plan changes, for example, with respect to the noise and vibration controls, in addition to the site-specific matters that are accepted by the applicant, what I'm referring to there is the Wakakatahi and Kiwirail appeals that address the way in which the interface, if you like, between private land and major transport infrastructure with respect to noise and vibration. Two approaches are available to you. Firstly, you could rely upon the planning outcome that will ultimately arise from those negotiations or any subsequent hearing, and omit corresponding controls from the PC 150 provisions. That's the most appropriate and efficient approach where there is no rationale for treating the PC 150 land differently from other land in the area. Now, in this case, there are some specific provisions that Mr. Adam has spoken about. So, and the zoning, of course, now deals with these issues in large part through the application of the commercial zoning along the state highway boundary. So they are site-specific responses, if you like, to issues. But secondly, you could incorporate site-specific provisions through PC 150. That approach is appropriate, as I said earlier, if you consider there's a rationale for treating this land differently. If not, it would result either in unnecessary duplication in the plan, or would incur the costs inherent in council subsequently notifying a plan change to rationalise the provision. So I think, sir, these are process matters that once you've made a decision, from our perspective, ideally would uphold the plan change, and you're then looking at how do we manage the interface between the plan change provisions of the precinct and the balance of the plan that are worth considering in detail then, but there are a range of ways of dealing with it. I think it's desirable to be as efficient as we can in terms of paper or bits, in terms of a plan that doesn't repeat itself unnecessarily. So I then turn to the key issues raised in the 42A report and the evidence. The first is in respect of wastewater infrastructure, and I see we've got some more evidence that's come in this morning too on that, and I've not had a chance to look at that. Others may well be scurrying away in the background in their own private offices doing so, but I've not looked at it. So this is all written well in advance of whatever's coming today. The provisions regarding wastewater infrastructure recently introduced through the Urban and Services Plan changes require any new development to obtain resource consent with regard to being had to wastewater infrastructure capacity. It is submitted that these are equally applicable to the PC 150 land and the balance of the Marsden and Ruakaka area. In other words, it's saying that when you're wanting to develop, look at where things are up to in terms of wastewater and how we're managing that as a community, as a settlement. And the evidence that's come through from council's infrastructure team is we know we need to do more. Here's some history as to where things have got to. The applicants say we know more needs to be done as well, and we'll be contributing to that along with everybody else. But the way to deal with it is to make a decision when you know what your proposal is, when you know when the proposal is being promoted, when you know what the provision of wastewater infrastructure is at that time and what's planned for the future. And we are going to be far more informed at that time in the future than we are today. So let's leave that decision till then. I've noted in A that the PC 150 land has been identified for urban development for over a decade, and the council has known throughout that time period that it would need to provide additional wastewater infrastructure capacity to cater for that and other development. That's one of the matters that informed the new plan provisions. Secondly, the urban services plan changes have resulted in urban zonings being applied to a number of additional sites in the vicinity. So the extent of urban land has now increased. There is no rationale for concluding that development on the PC 150 land, which has been zoned for urban purposes for at least a decade, should be the subject of stricter requirements in terms of wastewater than any other site in the district and in the vicinity. Now, Ms. Osborne's evidence for the council as submitter identified 4 options for provisions addressing wastewater infrastructure. Option 1 was the relief sought in the council submission. Option 2 was the revised provisions in the Three Waters Management Chapter of the WDP, adopted through the Urban and Services Plan changes. Adopting this option would impose similar controls on the PC 150 land as applied throughout the balance of the Marsden Ruakaka area, and this is the applicant's preferred option. That seems logical and fair and appropriate. Option 3 was an amended version of the WDP rule imposing additional obligations on development of the PC 150 land. So that would, and then 4 is a separate provision in the new Marsden City precinct, again imposing additional obligations on development of the PC 150 land. There's Ms. Osborne's preferred option, and that involves, in a sense, a different or a stricter test for this land than applies to all the land around it that's zoned urban. And we just think, in a nutshell, there's no rationale for that. You're going to be looking at this issue anyway, and it should be done in the same way, whether you're immediately south of industrial land at Marsden, or you're on this land, or you're some other location that's zoned for urban purposes, all of which will feed into the same basic piece of infrastructure and adds demands to it. So the implication of the relief sought by council as submitter, say in 6.3, is either that PC 150 land has unique circumstances that warrant treating it particularly stringently, or that the council officers considered that the resolution of the urban and services plan changes was insufficiently strict. It submitted that there's no rational basis for imposing additional constraints on the PC 150 land in comparison with the measures that the council has only recently accepted are appropriate for the balance of the district. There are no characteristics of our land that will alter the quality or components of the wastewater that was reduced from development on it in comparison with other parts of Marsden or Ruakaka. Are there no characteristics that make it more difficult to reticulate wastewater from that land to the treatment plant? And the quantity of wastewater that is reduced from development on the PC 150 land will be a function of the zoning and development decisions made by developers. The implications of that wastewater quantity for the capacity in the network will be assessed under the newly approved WDP provisions, as is the case for all other development in Marsden and Ruakaka. No further constraint or control is required. So those are the reasons why we say that option 2, reliance on the district plan provisions, is the most appropriate. Now, I've then set out in 6.4, Ms. Osborne's options 3 and 4, what the changes were that she was proposing. I won't read that to you in full. I'll let you just glance through it, perhaps. And then in 6.5, I make some brief comments on those options. On their face, the additional words relating to matters of discretion in options 3 and 4 do not add much, although they appear to be intended to make consenting more difficult for the PC 150 land. Secondly, the subparagraphs of options 3 and 4 that refer to anticipated land uses have more significant implications, should say. They imply that the council could impose conditions that govern future land uses on the site within the Marsden City precinct. My submission is that councils cannot lawfully impose conditions on a resource consent that constrain a landowner's right to seek future resource consents. I could offer it as an OSIA condition. I'm not, and I'm not even a resource consent situation to be in. And so such a provision as the one proposed by the council in my submission would be ultra vires. You can't impose a requirement on someone to do that. Secondly, there's no legitimate basis for distinguishing between applications under the WDP rule. Generally, which do not need to be publicly or limited notified, and applications in relation to the Marsden City Precinct. And I think there's a logic for that, because where you've got a wastewater issue, it's about the relationship between this proposal and the council's infrastructure and the capacity of that. And how do you manage that? That's not really a matter for everybody else to get involved in, presuming and assuming that the council is treating all landowners equally and is addressing this issue with knowledge that there's got quite an expanse of land that's been zoned for urban purposes, and it will need to upgrade its system at some time in the future. And I'm pretty sure that'll be what the evidence that's coming this morning is just recording. The evidence for council as submitted takes no account of the no doubt unintended consequences of applying stricter provisions to PC 150 land. And this is where we get down to lawyers going down rabbit holes there. Creating a distinction between the PC 150 land and the balance of the district invites a legal argument that the listing of additional matters for applications on the PC 150 land means that there is no requirement to consider those matters for applications outside the area. That is, the consequence of the additional wording may be an easing of the consenting path for proposals on all other properties, because the additional matters specified in the PC 150 land will be disregarded. Whereas if you treat them all the same, you don't have that ability to find a little wedge in which to insert your chisel and start working on. And I think that is an unintended consequence. It is the sort of thing that, as lawyers, we tend to look for. And it's worth avoiding them if you can. Second issue is the adequacy of open space. I'm going to deal with this very briefly. Mr. Badham has discussed it, and in his latest evidence, you'll see he has proposed some mechanisms for the provision of open space that he thinks is the most appropriate now in the context of where things have got to. He has, as I understand it, had a chance to discuss those matters, and I think agreed really essentially them with the council's reporting planner and district plan manager. I appreciate that's a different discussion from anyone with the council parks department, who are here as a submitter as opposed to being here as the regulatory authority. I don't know that I need to take you through that in any more detail. That's a matter that you'll hear some evidence on in any event. We come then to distributional effects and trade competition, and this was one of the matters you may recall we spoke to you about in the urban and services land plan changes, because there was a discussion about a hierarchy of centres or not in this case. And that issue has also disappeared essentially because of the way that things have progressed. But I'll take you through this just for completeness, and because we did touch upon it with you just some time ago. So pursuant to section 74.3, in preparing or changing any district plan, a TA must not have regard to trade competition or the effects of trade competition. It's accepted law, however, that regard can be had to the effects on the amenity of the public caused by any significant reductions in the viability or vitality of commercial centres that arise from trade competition. Such adverse effects on commercial centres can arise as a consequence of the redistribution of trade from one centre to another and are termed distributional or consequential effects. I then refer to the Supreme Court decision in Discount Brands, and I think from memory, sir, I may have taken you through that on the urban and services plan changes hearing. And
I can't remember, to be fair, but I do remember having been taken through it at some point, so it could well have been then.
Right. So I'm not going to read to you paragraph 6.11. It's just a bit of background to where we got to on that, and the attachment to this submission, the 2 pages at the end, are a series of quotes from the various High Court and Court of Appeal and Supreme Court decisions that set those matters out if you are interested in them and you need to go back to them. The critical point is in 6.12. We make the following observations. PC 150 alters the urban zoning of the land, but the district plan has provided for the Marsden Primary Centre in this location for over a decade. Accordingly, the decision to identify this land for a significant centre has already been made, and PC 150 does not substantively change the position. What it does allow is that centre to be rationalised and more limited in extent, but with a better mix of activities around it. Now, through the council hearings on the urban and services plan changes, the applicant's consultants recorded their view that the council's strategic planning documents established a hierarchy of centres in Marsden Ruakaka, with the Marsden Primary Centre being the largest centre and the Ruakaka shops being a lower order centre. Council officers considered that while the documents anticipated the Marsden Centre, they were ambiguous as to whether it should have priority over or parity with the Ruakaka shops in the hierarchy. Subsequently, the appeal by Marsden, which sought to clarify the relative status of the Marsden Primary Centre and the Ruakaka shops, was withdrawn, as with the corresponding wording in PC 150. So that really occurred because we had progress on this plan change, and we were heading towards getting a point where the issues on the ground were going to be determined anyway. And at that point, it becomes a matter of who does the better centre as to who does better in the future. As a consequence, PC 150 does not now seek any wording that addresses the centres hierarchy. Town Centre Properties Limited, the owners of the Ruakaka shops, has advised by memorandum dated 9 August that it supports the planning officer's recommendation that there be no change made to UFD P10 and the subsequent acceptance of that in the applicant's planning ordinance. So the applicant understands that this is no longer a matter of contention between the parties. The relative size and quality of the Marsden Primary Centre and Ruakaka shops in the future will be determined through competition, but there's no suggestion in any evidence that this will produce adverse distributional effects. So they're free to compete, and they'll have different rules because they came in at different times. That's just the nature of planning. I turn then to the strategic planning and transportation issues raised by Wakakatahi. Wakakatahi's submission is extremely broad. It is primarily concerned with strategic planning issues. Ms. Thompson's evidence for Wakakatahi concludes, "It is my opinion that there are a number of issues that need to be addressed before PC 150 can be adopted as notified, primarily those related to integrated land use as elaborated in section 4 of the statement. This section of the submissions will concentrate on the strategic planning issues relating to transport discussed in Ms. Thompson's evidence, section 4. Section 5 of Ms. Thompson's evidence discusses noise-sensitive activities, a topic that's addressed in the following section. So just be aware that this is dealing only with the strategic planning matters. Our submission is that Wakakatahi's position on PC 150 first fails to recognise that PC 150 will increase the transport self-sufficiency and efficiency of Marsden Ruakaka and will generate economic and social benefits by enabling the co-location of employment, retail, commercial and residential activities in a central location within this developing urban environment. So those benefits of what have been proposed are just not taken into account. And secondly, Wakakatahi endeavours to transfer responsibility for providing key transportation infrastructure in the broader area onto private landowners rather than responsible authorities, Wakakatahi and council. Now the next section, sir, I go through various statements of Ms. Thompson, and I'm not sure whether you want me to go through that in depth, or having read it, you're comfortable with it. Is this it is something I made, clearly I'm going to need to come back in reply, assuming Wakakatahi's position is unchanged, and I suspect it will be.
I don't think I've marked any questions on it, put it that way, so I'm just scrolling down to make sure I've not highlighted anything there. No, I've not highlighted any questions for you in that section. Have you any questions regarding that, Ms. Demery?
Just checking. No, I don't have questions on that section, thank you.
No, so I'm happy that we scoot past that, because as you say, there'll be things you'll need to pick up in your reply anyway, having heard.
And I think, sir, in essence, what we're saying is this plan change will provide a better integrated centre. It provides for the co-location of activities that complement each other, and by virtue of that, it's going to reduce demand for transportation between Whangarei, obviously, and Marsden Ruakaka. It's going to enable more efficient transportation within Ruakaka. It doesn't do anything to compromise public transport and the provision of it by the transport authorities. its location actually helps that because it's central, and its central location helps the provision of pedestrian cycling access when and if the council's able to get in place a network for that. But the applicant can't build that other than on its land. So there are the ability to do those things is limited to the 127 odd hectares that we have here. Beyond that, it's a function of a good location, which we have on the network and within the district generally, an ability to contribute to urban form. And I hope that the authorities will do things that recognise that and integrate with it. And so that, I think, enables us to scoot through quite a bit. What I have done in paragraph 6.17 is referred you to the Landco and Auckland City case back in 2007, where Judge Thompson, I think it was, made some very useful comments about the ability of private landowners to solve the city's transportation problems in the context of Auckland, and more accurately, their inability and the fact that we can't expect them to do that. Obviously, people, when they develop, contribute through ensuring that their site integrates well with the land, with the network around it. And they will make development contributions. But the responsibility for the roading network ultimately has to be for the roading authorities, both the council and in this case, with respect to the state highway network that runs past the site, Katahi. And that is made with particular reference to the suggestion in Mr. Norman's evidence for Wakakatahi that PC 150 be amended to incorporate a requirement to consider effects on the State Highway 1, State Highway 15 intersection, which is some distance away and accommodates a lot of traffic from a lot of different sources, only one of which will be this area here. I've said on the top of page 22, I've set out the reasons why I think that Landco decision is directly applicable in this case. We've moved rapidly through to page 22. So, vibration and noise. And the first category here is the Kiwi Rail submissions in respect of vibration and noise. And Mr. Ibbetson's evidence for the applicant addresses the relief sought by Kiwi Rail regarding additional controls on noise and vibration in response to alleged reverse sensitivity and/or health and safety effects. He and Mr. Badham will discuss the provisions the applicants prepared to accept. With reference to the additional relief sought in the Kiwi Rail submission, there is no evidence to establish that noise and vibration propagate differently in the immediate vicinity of the PC 150 land and elsewhere. So long as the WDP provisions do not exclude the PC 150 land from the application of the district-wide noise and vibration rules, you can rely on the outcomes of the Kiwi Rail and Wakakahi appeals on the urban and surface plan change. Now, what we're saying here is there is a separate discussion that's happening about the whole of the district and about how we deal with rail that goes through it and how we deal with state highways that go through it. That involves, I don't know, 20 parties. It's quite intense. It's got a process. The process is being worked through. I am hopeful that it will produce an agreed outcome. Now, South Park, one of the constituent parties to the partnership here, is party to that process. I'm also there for Kaingaora, so I do have an involvement in those appeals. That will produce, one expects and one hopes, a series of provisions that address these issues to the appropriate extent. It may or may not have distinctions between different parts of the rail and road network. It may or may not have distinctions between different parts of residential landing, whatever. But where it gets to should provide a fair and appropriate outcome for the region as a whole, the district as a whole, and of course for this site. If we need to have site-specific provisions in that, then that mechanism could potentially do that anyway. It's not necessary to resolve it here and now and in this process, and I think it's by far the most efficient to do it. All those issues are in detail in the context of this hearing.
Mr. Allen, you've emphasised, sorry, I'm just looking at that, you know, consistency of provisions and not having different ones, but then is there scope in that urban and services plan change appeal to add site-specific provisions for noise or vibration for this land? You've indicated, you know, is there a distinction in the rail network, for instance, and would there be scope to address it in the manner you're suggesting?
I think there's quite a lot of scope in those appeals because, for example, there are different zones where you might have different provisions applying. There are different parts of it may be the case that in urban areas we end up with a different result than in rural areas. I don't know. But what's open is how do we deal with this as a district in terms of these issues? And between not dealing with it at all and dealing with it in the way that the appellants that Kiwi Rail and Waka Kotahi suggest, you have a very big envelope of relief. And that is something that parties are working through. I'm not saying that I think there's a reason for treating this land differently, but if there was, in the context of the way that things were being analysed through there, then I'm pretty sure it could be incorporated. And it won't just be this site. There might be other sites that have similar characteristics, whatever measure people are looking at. I don't necessarily see it being a site-specific exclusion, although it's presumably possible. I think some parties may well have sought that for their land. I see it more likely as being in the context of a broader outcome. The land with certain characteristics have different provisions than land with other characteristics. But I can't tell you where it's going to get to because at the moment we're going through a lot of work. It's all in mediation, so it's all about prejudice, and it's an exercise where people are endeavouring to reach solutions.
Okay.
And I'm simply saying I think we're collectively better to reach solutions in that focused forum than we are to try and tack it on here.
Thank you.
Thank you.
The second issue then is noise, and Waka Kotahi, and this is really very, very briefly. Waka Kotahi expressed concern about the interface between State Highway 15 and the low density residential zone. We're trying to deal with that now through that change to the zoning pattern that I've shown you right on page 2. Saying, well, let's, rather than trying to get cute about funds and residential and lower density and all this, let's just put something that isn't sensitive to that activity and use it to be the buffer effectively. And in 6.21, I've said that both the Waka Kotahi and the Northport submissions provide scope for this change. Firstly, item 15, appendix 1 of the Waka Kotahi submission seeks deletion of the low density zone and its replacement with industrial or another zone that is less susceptible to noise, and I would say the commercial zone does that. Northport sought removal of residential uses in the vicinity of State Highway 15. This is what we're doing. That relief is given effect directly by the extension of the commercial zoning. With that zoning in place, as I said earlier, there's an appropriate noise buffer affected by distance and intervening activities between State Highway 15 and the balance of the notified low density residential zoning. The rationale for applying a lower density residential zoning to that rump land or that residual land no longer applies. The default residential zoning in the PC 150 area, general residential, can therefore appropriately be applied as a change that is consequential, I would say, upon the application of the commercial zoning alongside State Highway 15. But for completeness, I've also noted that there are a range of submissions that support residential zoning for Marsden City, and I've sent those out in 8 below, footnote 8. My submission, sir, is I think the rationalisation of the residential zoning is appropriately a consequential change upon the granting of the commercial zoning along the edge. I don't think you need to go beyond that in terms of scope. We are responding to a submission, 2 submissions, and we're giving effect to that relief. And as a consequence of that, other elements now become not the most appropriate way of giving effect to the policy framework, if you like. Okay. And of course, it's all internal to the site. It's dealing with the external issues being dealt with through that commercial zone. The next issue, sir, is reverse sensitivity, and this I think is the last of the issues I've got, which is the Refining New Zealand submission. And I've just in 6.23 set out the definition of reverse sensitivity in the ARC and ACC case. And I've referred to Blueskin Bay Forest Heights and Dunedin City, where the court, might be Judge Thompson again, made the observation, we accept the possibility that the secondary effect of event sensitivity may arise, but we think there does need to be a measure of robust realism about this. Those who might come to this area to live have to expect some rural noise and just have to accept that as a fact of life or not come at all. Now that's it's a refreshing approach, isn't it?
Well, is that still a current approach? Because I'm not aware, but I'm not up to speed on these things. But in terms of what's happened at Whanuapai, hasn't there been some contrary view expressed there?
I think you're thinking about PC5 through.
Yeah, I'm not aware of the details at all. But is that?
I think coming to a military airport is a slightly different circumstance from coming to a residential area, to a rural area in that case. So I guess what you would say is it's a case by case analysis, and what are the facts? What's the issue that's going to arise? What's the fear that you've got in terms of reverse sensitivity? So I then go on in the submissions and deal with that.
What did I mean, Ms. Dimmery may be more aware of it, but I'm not aware of what really did happen at Whanuapai. I've just heard that, that there was a reverse sensitivity issue which didn't come out in favour of the airbase necessarily. What did happen there?
Okay, I think I'll tell you what I know about Whanuapai Plan Change 5, Auckland City, which I think is the context for then some High Court proceedings that related to whether or not the way in which the airbase and the city should be interfacing, the designation in the city should be. Plan Change 5, as you can tell by the number, was quite an early plan change under the unitary plan. It's about 3.5 or 4 years now since that was notified. We haven't finished the first round of council hearings yet. We started them, then it got adjourned. And it got adjourned because the Air Force said, well, you shouldn't have these zonings in this location because we are in a position where we need to use test motors and maintain and do flights and all the rest of it. And then there was a debate about what the designation allowed, and that went off to the High Court, and the details of which I can't remember because I wasn't involved in it, except that it led to an inordinate delay in Plan Change 5. That was really about what the terms of the designation were, but the minister solved the issue by saying that the testing of the engines from memory, and it's very loose, the testing of the engines on the base was a necessary component, if you like, to New Zealand's defence, which cut off the argument at the knees. He could decree that. We then are going through another process and variations to try and change the zoning on the land in light of all those findings and progress. And that is currently promised to be notified by August. It wasn't. And the council's excuse is we need to understand what the Eden-Epsom decision means for us. At which point everybody who was a submitter just said that the Eden-Epsom decision has got nothing to do with this, but nevertheless. So that's a contextual discussion. I can find you the High Court material if you want, but I'm not sure that it's directly on this issue.
No, it's not. I didn't have a clear understanding of it, but I had it in the back of my mind when I read what you were saying in 623, right. And wondered whether or not it had updated
I don't think so. Having said that, I've had a case earlier this year in the Environment Court where the court basically said, well, relied on reverse sensitivity, but that was in an industrial area in Auckland. It's a factual assessment. So let's come to that, because I think the facts are quite important here.
Yeah. Sorry, Ms. Dimmery, did you have anything on that particular issue before or that particular part of this issue before we move on?
Yeah, my recollection of that case, that was a helpful summary. I remembered the engine testing being a key matter, but I do wonder to some extent whether there's some parallels here, that we do have two designations on the boundary of this property, and whether there's anything to be taken from that specifically.
I'm dealing here not so much with the road or with the rail, because those are addressed through the noise provisions and potentially the vibration discussion, and by the zoning issue. The issue for reverse sensitivity I'm dealing with here is the one raised by Refining New Zealand with their plant up the road.
I do understand that, but I wondered if there was also relevance with the road and rail.
Oh, no, and I don't think so. What, are we going to stop residential anywhere near major roads, which would be interesting given that we've just zoned in Auckland the upzoning of all the land alongside major roads so that there's more residential. I think we're at a point of accepting that the two activities can be adjacent to each other.
I'm simply asking the question whether there's relevance between the interplay of a designation and rezoning of land and reverse sensitivity issues, and whether that case assists us in any way.
Okay, I don't think it does. It may be that Waka Kotahi argue it does. We'll wait and hear, but I can't. Yes. I think the way of resolving that interface issue is not to try and separate major roads from any dwellings, because late for that. It's to determine what do you do to minimise the effects of the road, say, in terms of surfaces and the way that you construct it. What do you do, and where do you pass the responsibility to the developer of the dwelling or the person who's seeking new zoning to deal with those issues? So in this case, the way in which that issue of interface is addressed is through the zoning, by putting the commercial zoning next to the road. In some cases, it might be that you put in place a provision that deals with the way that the buildings are constructed, or where they're constructed, and the issues that are raised throughout the country by Waka Kotahi are, should you have a rule that says you must build to a certain standard? And in some places, of course, we already have that. And realistically, that's what people tend to do when they're building next to ports or they're building next to industrial areas. And these days, it's not uncommon to have a requirement that says you're going to build to a certain standard. You're going to be able. You need to ventilate it in a way that enables people to have fresh air and potentially cool air. Some cases where people put in air conditioning as opposed to just ventilation systems to ensure that they can sleep comfortably with whatever it is you have coming alongside. And that's the issue, in a sense, it's the subject of the Urban Services plan change discussion. Where does the responsibility lie, and when do you bring in a rule? But I think it's more that issue. It's more direct effects in the management of them than it is reverse sensitivity. Well, put it this way: if it's characterised as a reverse sensitivity issue, the way you resolve it is through those measures, zonings, and potentially, and mitigation of effects on your road or your rail, and mitigation of effects at the new dwellings. And it's the mix of those that needs to be sorted out.
So in this instance, we are looking at zoning, so it is relevant to an extent and has been addressed.
Well, it's been addressed,
in your view, yes. Thank you.
Yep. Whether you characterise it as reverse sensitivity or something else, the issue's been addressed, put it that way. Because there's a discussion about whether it's a health and safety issue, or just a amenity issue, or a reverse sensitivity issue. And in terms of
But
reverse
in a broad sense, bringing residential next to significant infrastructure is a reverse sensitivity issue. Introducing a more sensitive.
It can give rise to one. I think we're probably looking at just angles of how you describe it. I think the fact is there's an issue, and whatever you call it.
Hold on, Mr. Allen. It's rather clear, isn't it? Introducing a more sensitive activity next to an existing significant infrastructure is a reverse sensitivity effect.
It can it can give rise to a reverse sensitivity effect. Arises when a new activity comes in, and the other activity is affected in some way. Now, see, if I go back to 6.23, reverse sensitivity is the effects of the existence of sensitive activities on the activities in the vicinity, particularly by leading to constraints in the carrying on of those other activities. It's this, you need to move beyond the proximity to an effect to give rise to a reverse sensitivity effect. And I don't know any roads that have been closed down as a consequence of houses next to them. Or what the worst that happens is that occasionally we get buffer walls being built, and that's dealing with the direct effect of the road. It's a way of mitigating the effect. But I think my reading of reverse sensitivity effect is I need to go beyond mere proximity to have an effect on the activity that's caused the impolite activity, if I can say that way, or the one that creates the effect that's of concern to the sensitive activity. And if you don't get to that second point, all you've got is proximity of two activities that to some extent are conflicting or extremes incompatible. But we don't, if for example, you have a mushroom farm and you have residential next door, and in the end that means that you can't run your mushroom farm, that's a reverse sensitivity effect, clearly. But if you have a road and it stays and it continues to be open to traffic, that's not a reverse sensitivity effect, but it does create an issue on the boundary that we need to address, ideally.
So what you're saying then is, if let's say the dwelling was appropriately triple glazed or whatever, there was no effect, and therefore there's no reverse sensitivity issue.
Well, if there is a reverse sensitivity issue that arises, then that's a way of mitigating it. Yep.
Yeah.
I think what we're really dealing with here is the direct effect of the road on a hypothetical house next door, and it's not going to stop the road running, so it's not direct. It's not a reverse sensitivity effect, but it might make amenity inappropriate on the house. So how do you deal with that? And so to some extent, the roading authority can do it. Road surface, walls, or bund of some sort. To some extent, the housing person could deal with it by reducing by improving the quality of the construction of their house, or by orientating the house in a particular way. So it's a much more, I think it's a direct effect that you're dealing with here, not necessarily a reverse sensitivity one. And I think that means, obviously, the debates we're having in the Environment Court are acknowledging that these are issues you do need to deal with, no matter how you characterise them.
Thank you.
Thank you. So, turning to the site, 6.24, the Refining NZ evidence records that the alleged reverse sensitivity effect is related, at least primarily, to odour emissions from the refinery. The refinery activities are subject to resource consent conditions to the effect that no offensive odours shall be present beyond the boundary of that site. That's not an uncommon formulation of words, I'm sure, for all of us. That there are extensive areas of residential activity closer to the refinery than the PC 150 land, and that's apparent clearly from both the site visit, but also from maps. And complaints have been received from those residential areas regarding odour, some of which the refinery appears to accept relate to its activities. The refinery's evidence indicates that there are only a small number of complaints. Table 1 in Mr. Chilton's evidence identifies a total of 27 complaints since 2015, a period of 6.5 years, of which he appears to consider at least 5 to have been unrelated to the refinery. That's an average of just over 4 complaints per year. So our submission is the following. First, that the PC 150 land is at the closest approximately 4 kilometres away from the refinery. If the refinery complies with its conditions of consent, offensive odours from the refinery would not be received at the PC 150 land, and it is inconceivable in my submission that a reverse sensitivity issue could arise. Secondly, if the refinery is generating complaints as a response to odour emissions that contravene the conditions of consent, that are not lawful, if you like, then that is an issue related to the lawfulness of the refinery's operations, not reverse sensitivity. Thirdly, the fact that a complaint is received does not equate to a reverse sensitivity effect having occurred. It's only if complaints adversely affect the ongoing operation of an activity that a reverse sensitivity effect should arise, is what it should say, not sensibly. Fourth, nor is responding to complaints a constraint on industrial activity. The activity can continue unchanged, provided the operator can satisfy the council that any complaint is unjustified. So there is no evidence before you that the refinery's operations have been curtailed as a consequence of complaints or the presence of residential activities. That is, as I understand it, reverse sensitivity effects have not arisen to date. There is no realistic prospect, we would say, that enabling residential activities almost 4 kilometres away will change that position. Refining NZ has suggested that no complaints covenants be registered against the titles of the incoming activities. In that regard, first point I make is that no complaints covenants entered into by agreement between parties are not necessarily contrary to public policy or unlawful. So there is law that says you can do it. The mechanism has been included in the Auckland Unitary Plan, where the inclusion of a covenant in an application alters planning status. So down on the Western Reclamation, you're, I think, restricted discretionary if you, for certain activities, if you have a covenant in place, and I think you're either full discretionary or non-complying if you don't. It is submitted, however, that district plan provisions cannot impose an obligation on a landowner to enter into a private contract. Leaving aside the legality of the Auckland Unitary Plan provisions, and they were never the subject of a contested debate. And those covenants apply to sites in the immediate vicinity of the industrial activity of concern. In other words, I don't know if you're familiar with the Sandford factory on the Western Reclamation, Wynyard Quarter these days, immediately to the south.
Wynyard Quarter.
Yes, Wynyard Quarter. The south and the east of that site are residential dwellings and a hotel. And within the Sandford plant is an ammonia plant, ice making machine. That is the activity in respect of which there is some concern. And the covenants are provided for the properties. There's a band that shows where you need a covenant to be able to get the different activity status. There's no basis, I say in C, for concluding that such provisions could appropriately be applied to land approximately 4 kilometres away from the activity. And in my submission, councillors do not countenance transferring responsibility for mitigating these adverse odour effects from the refinery onto remote private landowners. Coming to the conclusion, Marsden Primary Centre, we're almost out of time, almost 10:30. The Marsden Primary Centre is subject to an existing urban zoning and has long been identified by council as a suitable location for a significant commercial centre. It's strategically located in the centre of the Marsden Ruakaka area on the arterial road network and adjacent to the proposed rail line. All those things we would say are good things. The existing provisions are, however, unnecessarily complex and not well aligned with the development intentions of the applicant. PC 150 will replace those provisions with zonings in the precinct that more accurately reflect the development intentions of the applicant, enable an appropriately sized centre which will in time serve the broader Marsden Ruakaka area along with complementary residential and commercial activities, will take advantage of the land's strategic location on the transport network, and by facilitating the co-location of retail, commercial and residential activities, promote transport efficiency, and will contribute over time to the creation of a connected and coherent urban form for the Marsden Ruakaka area. So we ask that you uphold the plan change on the basis that will be proposed by Mr. Badham immediately after morning tea, I suspect.
Great, thank you. I apologise, I have a helicopter hovering over my office by the feel of it. Ms. Dimmery, did you have any questions before for Mr. Allen?
Just one brief question, please, on the covenant issue you just referred to. So I take that you're saying that you could have a rule that alters planning status, depending on whether or not the covenant exists.
As
But
a matter
I'm
of law,
interested to know what the point of that would be if you can't impose it as a condition without the agreement of the applicant. Am I?
No,
so
no. What I'm saying, technically, in terms of what Auckland Council has done,
yes.
if you were to replicate what they do, you could have a rule that says with a covenant, a no complaints covenant or whatever, you have RDA status. Without it, you have full discretionary say.
Yes.
Then what I am saying, though, is if you can't then, on a resource consent application for a full discretionary, where somebody says, I don't want a covenant, say,
exactly.
I now impose a condition, requiring you to have a covenant.
So what would be the purpose of the rule then?
Oh, well, what it is in the Wynyard Quarter, which is I get an RDA status with a covenant in place, and I don't have to battle with all effects that are raised in a full discretionary. So, but the gloss or the additional comment I would make here, just to re-emphasize, those are all covenants on this piece of land relative to a problem potentially on that piece of land. They are adjacent to each other or across the street.
I understand you've made that point clearly about the oil refinery being some distance, but thank you.
You're on mute, Mr. Knott.
So I was conscious that I didn't want you being drowned out by the helicopter. Ms. Demery, anything else from you?
Rewinding some time ago to your wastewater discussion.
Full
flights, and I didn't want to interrupt Mr. Allen. I recall in the application documentation there was a discussion about a developer's agreement or similar for the wastewater,
right?
And
yes.
that now being nullified because it's no longer proposed to proceed. What was the legal basis for that? And is it open to council to seek the same approach now with this piece of land outside of the district plan process?
I presume it was, and I can't recall the details. Mr. Badham may have more information on it. I can't. It would have been an agreement between the council as the asset provider and a number of developers regarding the funding. Essentially, it's a funding agreement for infrastructure.
Yes.
Could the council do a similar thing? Yes, council can do similar things. Of course, you've got a lot of parties. You've got a slightly more busy context now than you might have had back then. And I think the way that the council has resolved it in a formal sense is to say, is through resource consent requirements under the plan changes. So there are obligations under the through the provisions introduced by the Urban and Services plan changes to require consideration of the matters that, and Mr. Badham can take you through these when he speaks, through matters that deal with the issue of adequacy of wastewater provision. And of course, the other way council can deal with it is to say, well, let's impose some development contributions that provide funding for that work. The issue we've got at the moment, Auckland is particularly bad, but Hamilton is also in the same category, is where councils are saying, well, we're not going to do anything because we haven't got enough money to do it. And we've just had a Plan Change 5 in Whenuapai is in a sense, a victim of that, as well as the complexities relating to noise. Drury is a problem. We have areas that the council and the government have said are essential to accommodating growth in Auckland, and council's opposing it as a submitter as opposed to otherwise. It's the perennial funding issue, but the mechanisms we have, development contributions, planning status, which the Urban and Services plan changes addressed, and the possibility of people doing, obviously, central government funding, apparently bottomless pit, which isn't. If you need to refine it, the ability for council to reach agreements with developers. But if you have a development contribution regime that's fair and works, that sort of avoids that need. The question is whether your DC's policy is strong enough to, and apt enough to deal with these issues without having to go to a side agreement, which brings its own complexities.
Thank you.
What I would say on that, I think, is my view is that funding of infrastructure, a plan for infrastructure and a plan for zoning need to be thought about in conjunction with each other. But if we get to a point where the zoning is, where the process is sequential, and it's only when you've got all your funding sorted out for your infrastructure that you then zone the land, you are adding in a whole delay of the zoning process, and you've also got a problem because the developers aren't able to develop, and they don't have no certainty, and they can't get funding, and they can't do anything. So it's essential. You can zone land and then deal with the infrastructure thereafter, because you've got to put the infrastructure in place to develop the land. So there's a real incentive, and when you've zoned the land, there's an ability for developers to get funding and start doing their part of the infrastructure. But if we get to the point where we don't do any zoning until the infrastructure in place, we've got just this almost catatonic state that we have in Auckland at the moment, where council would have nothing happening. Which is, I mean, obviously here we have a slight advantage over those places because we are at least urban zoned. So things can be done. They just wouldn't be done as well under the urban zoning we have now as they would be done under the BC 150 provisions.
Good. Okay. Anything else?
Nothing further from me. Thank you.
No, there's nothing further from me because I picked things up on the way through. It's now 10:38. Shall we break till 11, which will allow the council people who are able to go out for coffees to get a coffee, I'm sure, and those of us who are not so good at operating our coffee machines at home to make a coffee as well. So yes, we'll adjourn till 11. And do we have Mr. Badham next?
We do, sir, with his introductory statement as opposed to his detailed one that comes in.
Yeah, fine, good. Okay, excellent, good. So we'll adjourn till 11. Thanks, everyone.
Thank you very much.
See you then. Thanks.
Thank you.